In this installment of our discussion of school law, we're going to begin the discussion of employment law and starting with the issue of liability and tort liability. And so, what is the responsibility for school and district personnel in protecting the health and safety of students under their supervision? It's assumed that professionals will take affirmative steps to the greatest extent possible that a school environment is safe and conducive for students. But by and large, the courts have fallen short of ruling that students have a constitutional right to be absolutely protected from harm at school. And so this is where the issue of torts come in. And a tort is a civil wrong. It's a situation where the court essentially determines the law of someone being wronged. So negligence is the most common tort that we deal with in the school world. The elements of negligence are duty, the duty that you have that's reasonably articulated, the breach of duty, and the cause in fact causation, which is injury that results from breach of duty. And then proximate cause, which is this idea of foreseeability, that it was foreseeable by a reasonably prudent person. And then the other element, the final element, is damages, and that's basically that injury results in damages. And so how do you defend yourself against torts or defend yourself against this notion of negligence? Well, the first defense is something called contributory negligence, and that's where there is negligence that is spread on both parties, so that the plaintiff contributed to the breach of duty in addition and the damages. And then there's the assumption of risk, and that's you knew the risk and you gave consent of hold harmless. This is an example of parents knowing that their kids get on a bus, they assume that risk. That's a defense, that they understand that going on the road there are risks of accidents. One of the other issues is this notion of sovereign immunity and statutory immunity, and that is that there is a sovereignty from the state that protects districts, but not always individuals. So the district can, in some cases, not be held where individuals can be held. But there's also a level of statutory immunity where state laws grant immunity, and something that came through NCLB called the Teacher Protection Act of 2001, which pretty much protects teachers against everything except for flagrant disregard and reckless misconduct. One exception there is you are not protected if you have students in your motor vehicle. So just understand that. So how do you manage the risk of tort liability if you're an administrator in a school district? Well, obviously, insurance is one way to mitigate and manage that risk. Another prominent way is supervision. And we're going to talk about different levels of supervision and how important supervision is in managing risk of tort liability. And then a final way is making sure that you have safe facilities, safe buses, safe things that students are surrounded by while they're on your watch at school. And so let's talk a little bit about some of the aspects of individual liability. In the school is a safe place. Under certain conditions, personnel are held individually liable for actions that result in the injury. And liability is generally imposed in instances where it can be demonstrated that a school employee's action violated clearly established law and that the employee exhibited reckless disregard for the rights of the plaintiff. In the Wood v. Strickland case, 3 high school students were expelled for spiking punch at a school-sponsored event, which was in violation of school policy. The board expelled these students for the remainder of the semester, which is 3 months, and the students and their parents filed suit. And the federal statute provides that any person who are under the color of state law deprive anyone from jurisdiction of the United States constitutional rights secured by federal law liable to the injured party in the lawsuit for monetary damages. And the Supreme Court, in looking at this case, held that school officials' immunity from monetary damages depends on two elements. The officials acted with sincere belief that they were doing the right without malicious intent to deprive the students of their constitutional rights, and that two, officials lose immunity if they knew or should have reasonably known the action they took would violate constitutional rights. And so the Supreme Court really clarifies in several other cases the conditions under which damages can be recovered, but there has to be proof and liability and willfully violated these things by school officials. So it goes back to that reckless disregard. And so issues that also come up in much of the case law, and we're not going to get too case heavy in this because there's so many cases, but the supervision before school, there is responsibility for supervision of students once they arrive on school grounds before the school day. That degree of supervision depends on the circumstances. School personnel are expected to foresee, and this is the foreseeability issue, that early arriving students may be injured under certain circumstances. And once this determination is made, prudent steps should be made to prevent the harm of students in your supervision. Liability involving bus stops. This is the idea of the threshold to threshold. Schools are typically not held accountable for student safety at bus stops based on a whole bunch of factors beyond the control of the schools, such as traffic patterns, speed limits, driver negligence, student conduct, parental responsibility. The school district's responsibility begins when the student actually boards the bus, and there should be written rules and regulations governing conduct on the bus, as well as the consequence of when these rules are violated. Parents should be informed of the student conduct so that they can be reinforced at home, and school leaders are aware that misconduct at bus stops, they should inform the parents of this misconduct, but they may be disciplined for off-campus misconduct if such affects school discipline. But generally speaking, the bus stop is off limits. When it comes to field trips and buses, school-sponsored field trips are viewed as an extension of normal school activities, and they provide learning experiences for students that complement their classroom activities. But to minimize personal liability, most cases they use school-owned buses, commercially leased buses, rather than automobiles driven by teachers and parents. Reasonable standards of supervision must be exercised by personnel because students are most often in environments where they're not familiar. Age, maturity of students are all considerations, but there have been several cases, generally speaking, where if reasonable mechanisms are applied, the King versus Cardison case is an example in Nashville nearby, where the students tried to cross the street, and the students did get permission from the teachers, and the students were 13 years old. They were hit by the car, and one of the students was severely injured. I think the other was killed, and the school personnel were not held liable because the determination of the court was the student was 13 with no hearing or vision problems and was regarded as mature enough to determine how not to get hit by a car. And so, the detention is another issue where it's a permissible form of punishment if it's administered in a prudent manner, consistent with policy. And these policies typically require parental notification. Wooford versus Evans case is a 14th Amendment case from Virginia, where the school failed to notify parents about detaining their child during the investigation of some allegations about their misconduct, and they held school officials did not violate the parents' 14th Amendment right to due process by not notifying them of detention. They concluded further that the detention was necessary to investigate reports of the child who could have had a weapon at school. So again, there's in most cases, you still go by those standards of what is reasonable, but also making sure that you look at the reckless disregard of the rights of the plaintiff. The idea of educational malpractice is one final thing that we want to mention, and that's the a threat to educators in the past couple decades, where parents have brought legal challenges on behalf of their children, alleging that they were unable or unwilling to provide competent instruction, which actually academically injured the child. Academic injury is based on the view that the children do not receive the full benefits of education. A lot of suits on this, but none have been successful to date. With the emergence of site-based councils and different standards and NCLB and other accountability pieces, it's not surprising that parents see a little more firsthand the academic success of their student or lack thereof. And you see probably the most noteworthy case is the Hoffman v. Board of Ed from New York City. In this case, they ruled on the behalf of the student, indicated that they had suffered academic injury based on diminished intellectual development and psychological injury stemming from inappropriate placement. The student scored a point below normal on verbal abilities test that resulted from him being placed in programs for students that were mentally disabled when the plaintiff only had a speech defect. So it was not until the plaintiff applied for Social Security that it was determined that he had an IQ of 94. The suit was filed upon that discovery, and the lower court held for the student based on those facts. However, the New York Court of Appeals reversed the decision for public policy reasons. And so, where the trial court said the student had been improperly diagnosed, and they believed that the students, there was a different rule that applied. Negligence is negligence, even if the defendant prefers semantically to call it educational malpractice. So the rulings based on public policy that were the outcome of the Court of Appeals, however, suggest that the courts historically have failed to recognize this educational malpractice as an appropriate course of action. The historical view based on public policy it really suggests that the court will always follow the line of reasoning that educational malpractice is not something that is going to be the schools are going to be negligent for. So it's more likely than not that a court in the future may rule on the facts that give rise to academic injury, but it hasn't happened to date.